invent something, where you invent something, and such invention is being granted a patent number, there's a patent application is there, then there are specifications on which you will be granted patent. Now these are the basic elements of patenting, but the laws regarding patent do change country to country. Like one country has one kind of a patent, other country has a different kind of patent. So will do a comparative analysis today regarding US, UK, and Japan. Like these are the most major patenting nations where we'll be dealing the difference between all these nations. Basically, we'll see US patent. Now, now before going to US, Indian Patent Act, that is 1970, gives you a patent right of 20 years. That is, you can exploit a product, patenting of a product for at least 20 years. No, this is the duration of India, but you can't guarantee the same duration over some other nations too. The durations would be changing, the licensing would change, the measures would change, the laws would change, the regulations would change. So everything doesn't remain the same. Now, there is a patent office in US, that is United States Patent and Trademark Office. Like the person who will be handling patent as well as trademark, that person will be the registrar, will be the person capable of who is capable of granting you patent. Then I go to, that is the basic overview of United States patent. Uh, According to General Agreement on Tariffs and Trade (GATT), according to that, the the patent norms are being made out. Give me a minute. Give me a minute. Yeah. Now that is GATT got effective from the year 1966. 1996. I'm sorry. From the year 1996, it got patented. Now there are different kinds of patent under US. That is, US law asks for a different rules and regulations. It is not as Indian patent is. No, in India, they need, like, you should be major, you should be solvent, uh, you should be not disqualified by law. These are the requirements under Indian Patent Act. But in US, anybody, regardless to age, sex, or regard to official capacity or nationality, can apply for patent. That is, even if I'm a minor, I can apply for patent. Even if I'm, what do you say, a stateless, that is, I may not belong to US, but I can still apply for patent. Then I may be male, female, anybody. I can apply for patent, provided I should have invented the invention by myself. Then there are kinds of patent under US. That is utility patent. This is the general type of patent where the general public is most familiar with. That is anybody who makes a new product which is useful to the public, and one which is non-obvious. That is a product I make, or a thing I make, and which is known to the public that this is the product. And for these products and all, you'll get, what do you say, you will get patent. This is known to the general public like us. Next is plant patent. This is a different kind of patent which is not applicable in India. A new variety of plant, that is a plant founded in an uncultivated state which has been asexually reproduced. That is a plant which is reproduced by an asexual method. Such plants are being given patent. Then design patent. Next, other than normal patent, plant patent, and design patent. That is a design which is given to an ornament, any ornament which a design is given, or what do you say, any article, any manufacturing process. For example, a bottle, it may be granted a design, or a car, you may design it in some way or the other. Now, for these and all, you get patent. But then these are only limited to the designs that are created. Now, before GATT, there is General Agreements of on Tariff and Trade. Before GATT, the plant patents begin the date and the issuance ends after 20 years of filing. That is the uh, earlier, before GATT came into force, it was only 17 years. That is, if you go for a plant patent, the patent will long last for only 17 years. But after General Agreement on Tariff and Trade came into force, the term was increased by 3 years. All patents which are invented in USA will get the term of 20 years. Then, if at all there are any delays, any interferences, any objections to the granting of patent, they'll grant extra 5 years, additional 5 years to the patent. Then, what are the criterias for patenting? Uh, as everybody knows, the criteria is, well, like the rule is one who first invents. See, there are two things: one who first applies and one who first invents. He should like uh, first applicant is not important, but you should have first invented. I may apply first, but I might not have invented first. Like somebody else might have invented first. May have not invented first, but I may have applied first. So only the person who invents first will get the right of patent. But once you first invent the application, no, you should be the first person who has to file it. Now you should not take it from somebody, any material from internet. You cannot copy paste it. These are not done. These things you can't do. Then contents for patent application. That is, if I am putting an application for patent, what should be the content? First is specification. What do you mean by specification? Specification is nothing but the description of the invention. For example, I've invented a gel or a scent which will remain in my body for 3 more days or 4 days. How many days it can remain with me for long. And then claim. Now claim is what am I inventing and what am I claiming through my invention? Like suppose you claim something or you invent something. Along with that invention, what do you claim in that invention? Invention is not big, But what do you claim in that invention? That is, a claim is essentially meets all the bounds and descriptions which are encapsulates invention and distinguishes from prior art. That is, I have to say it in my specification that whatever, well, in my claim, that whatever I'm claiming is my new and original invention, and I haven't copied it from anywhere else. Then next is drawing. Now, what is drawing? Drawing is the essential art which you show it to the patent authority. That is, this is my invention. This is how the invention works. This is a drawing which you give. You give it to the patent controller, the grantor of patent, saying that I have invented this, and through what process? What are the process I went through to invent such a thing? Then oath. That is, now oath is nothing but your affidavit. That is, you say that whatever I say is a declaration. Whatever I say is true and best of my knowledge. That is your oath. That is what whatever I have said in my statements are actually true, and there's no what do you say? There's no secret with me. Whatever invention is there, I'm saying it in my true sense. I am not manipulated anything. Everything which I'm saying is true. Then next is fee. Now the filing fee. That is, if I file for patent now, the basic fee, that is, uh, for utility patent, that is the general patent which I talked about, is $750, and for design patent it is $330, and for plant patent it is $520. That is, if I'm patenting a plant, I should pay $520. If I'm patenting a design, I should pay $330. If I'm patenting general, like that is utility patent, that is $750 for per application. But then, if you are poor, or if you are a very small institution, then what they'll do is they'll give you relaxation. You need not be paying it completely. Now you can pay half of the amount. Then, uh, processing patent application. Now, what is that? I I have a patent application which I have given to the officer. Uh, there is an office called Patent and Trademark Office, and they will take a decision. Patent and Trademark Office, where I have to publish my where I have to give my details of my invention, like what I have invented, and then what is my invention, what are my documents, entirely. I should file it at the office. Then, once I file my patent application, and complete secrecy will be maintained. Secrecy means nothing will be leaked. Nobody will be told nothing. Then, then, once your invention is allowed, or once your invention is accepted, what they'll do is they will grant you Like they'll call you for notice of allowance. That is to come and like come and see what are your inventions, what is your applications, or if there is any error, then in fact, like there are no errors, but if at all there are errors, you have to clear your errors. Then you have to pay a fees that is apart from the application fee. That is for utility patent, you have to pay for utility patent, you have to pay $1,300. For design patent, you have to pay $470, and for plant patent, you have to pay $630. Apart from the application fee you pay in the first stage. So this is different from the application fee you pay. Then now I go to comparison with United States patenting laws with other nations. Now first I'll compare it with Patent Convention. That is, I'll compare it with Europe. Like now, US will be compared with Europe. European Patent Convention or Convention on Grant of European Patents, which was enacted in the year 1973. European Patent Organization and System. This is the machinery which grants patent in Europe. Then, but this EPO, what do you say, European Patent Organization goes beyond Patent Cooperation Treaty. That is, you have to apply only one single application wherever you are. Wherever you are, one single application for entire Europe. If your invention is accepted, they'll process your application. Then what EPO will do? EPO will do a novelty search. Now, what is novelty search? Novelty search is nothing but they'll check whether the invention a particular person is claiming, is it true, or is it fair enough that that invention is new and nobody else has invented such an invention. Then there'll be three examiners, that is to examine the application, patent application. And which will be equivalent to the national procedure. That is the basic. Wherever you are, like in European continent, in whichever nation you are, you are supposed to follow that. The procedure will be followed by them. Then, once the officer says the patent should be granted to you, then the EPO, that is European Patent Organization, will grant you a patent document. That is a certificate. Now, once EPO grants you a patent, it is applicable to all the nations, whether I travel anywhere in Europe. Like once they give me like once they give me any kind of relaxation in EPO, that is European Patent Organization. Once they grant me something, it will be applicable to entire Europe. Then now once I grant it, now this is a here in Europe the procedure is little different. In India, you can raise objections before patent is granted, but in Europe, a person can raise objection after granting of patent. Once the patent is granted, they can raise objections. that objections can be raised within 9 months. Then, once the patent is found invalid, or once the patent is found that it has been copied from someone, then they'll make it invalid. Nowhere else you can claim the patent because it has been declared invalid. Then, now, like US, there's only one court. Like you can go to US federal court and you can get the judgment. But this is not the case in Europe. You have to file separate applications everywhere. Then you have to defer the claim. Then you have to fight with the claim, and then you can get back your patent. Now, the differences between US patenting system and European patenting system. Now, in Europe, the first one who applies first will get the patent, irrespective of who invented it. For example, I invented it, but Mr. X goes and applies it. X will get the patent because he's the first applicant. But this is not the rule in US. The first inventor will only get the patent, not the first applicant. But in Europe, it is the other way around. The first applicant will get the patent, not the first inventor. Next is grace period. Now, EPC. What European Patent Council says, Cooperation says that once your invention is publicly known to people, your invention will be rejected. You cannot write it in your novels. If you're writing a novel and if you're inventing something, you can't write the same thing in your novel, or you can't tell it to your friend, or you can't put it in a movie, or you can't perform a drama over your invention. If it is known to the public anyway or the other, your invention will be cancelled. That is section 54 of European Patent Act, that is patent application. Section 54 says any kind of knowledge about your patent before the grant of patent, your patent application will be cancelled. Now, best mode requirement. In US, you have to say after granting me patent, what will I do with this patent? Like, how will I advantageously use, or what is the benefit of this patent? I'm going to do it. Now, this is you can do it in US, but the same cannot be carried over in Europe. Now, rights conferred by granted patent. Now, once US grants you patent, it's your property. Now, patent is nothing but your intellectual property, and US also regards patent as your property. And throughout the United States of America, whichever country you go, that is, there are 52 nations altogether, they have formed one country. No matter wherever you go, your patent will be protected. You will be given protection because it is your invention, it is your idea. Now, that is in US, Section 35 of US Code says that nobody can infringe particular person's patent. If anybody infringes, he is liable to be punished. But then in Europe, anybody can use your patent. That is their signed nation. That is European Patent Convention, a treaty signed by 27 countries, 27 European countries. Let me name the countries, the European countries which are there: Austria, Belgium, Bulgaria, Switzerland, Cyprus, Czech Republic, Germany, Denmark, Estonia, Spain, Finland, France, Greece, Hungary, Ireland, Italy, Liechtenstein, Luxembourg, Monaco, Netherlands, Portugal, Romania, Slovenia, Slovakia, Sweden, Turkey, and United Kingdom. Now, all these are signatories of European Patent Convention. And then these conventions, those who are signatory to these convention, this will give the right to the owner as well as these countries to use the invention. That is, this 27 countries can use the invention without the inventor's permission. Then, next is opposition after grant. Like under European patent, no, within 9 months of grant of European patent, anybody can file opposition, stating why this patent should not be granted. That is, once the patent is granted to you, there's 9 months duration. Anybody who wants to raise objection over the grant of patent can raise objection over the grant of patent. But then the European Patent Organization, like the European Patent Office, the decision by European Patent Office is final. Like anybody raises objection over my invention, then I disprove their claim. Then the final authority to decide the matter is European Patent Office. Then, but in USA there is re-examination. Re-examination means what? I go for patenting my product, then somebody raises an objection, then that objection will be accepted, then that party will be called, then I'll be again called for examination. That is called as re-examination. It is before the grant of patent I can do it. This is in US, but in Europe you do it after the grant of patent. Next is inventive step. Now, what is inventive step? Anything which you do which is non-obvious in nature, that is inventive step. That is Article 52 of European Patent Convention says that anything a person is trying to patent it, that person should that person who is trying to patent his invention, it should be new and it should involve an inventive step. But then under US, what it says is your invention should be new, but whatever methods you're approaching now, that should be non-obvious. That is nothing but which is inventive. Here, Europe and the European Convention, they are talking about inventive step. Under US, they are talking about non-obviousness. Non-obviousness means one which is not an obvious result of anything. But then when you go to Patent Cooperation Treaty, the PCT, the main treaty which I taught you in the last class, PCT requires inventive step. PCT says there should be an inventive step, and the product which you are claiming to be a patent should be novel, should be new. And I'll give an example. If invention relates to bike with a reflector and the closer prior art is a bike with no lights at all, the technical problem is to enhance the visibility of the driver during dark weather conditions. The problem is solved by adding a reflector to the bike, since the reflector allows other road participants to see the driver on his bike in the dark due to light reflecting on it. Now, when like suppose I'm traveling at night and I have a like my bike lights are not that good, so I'll make a reflector so that I can see the road well and others can also see me. That reflector is what that helps you to see the road as well as to others can also see you. That is where there is a problem and you solve that problem. That is what it is required. There is already a problem, but that problem needs to be solved. So for to solving that problem, you take out an inventive step. That's where you get a patent. But then next question comes into your mind is whether the solution is obvious. No, definitely not. Obvious means what everybody would have predicted that. But when I talk about non-obviousness and when I talk about inventive step, both should be unpredicted. There is nobody should have known that such kind of thing is there, but you have invented, you have made it. Then only I can claim, you can claim it. Next is Japanese patenting system. Like now I go to first I we dealt with US, then we dealt with Europe. Now we come to Japanese patenting system. Now Japan, in Japan there is a Patent Act 1959. Okay, in India there's Patent Act is called 1970. But in Japan, Patent Act is of 1959. Then in 1895, they generally codified the patent law. Now, Japanese Patent Office, JPO, are the administrators, examiners for granting of patent rights in Japan. That is, JPO is the office which will grant patent to the people, or which is a very important office which grants patent. JPO is an agency of Ministry of International Trade and Industry. MITI, Ministry of International Trade and Industry. MITI. Now, MITI is a machinery of information, industries, and trade policy. The patent commissioner, the patent authority, is a person who is a senior career MITI official appointed by MITI minister. Then the patent officer usually retires after 2 to 3 years. The term is for the patent office is for 2 to 3 years. He can be a patent officer. Then let me go to the comparative analysis. See, claim. Now, like I'll the claim in Japan, the claim under PCT, the claim under USA, the claim under EPC. All these are different. See, the term that is the title of the invention needs to be given in Japan. That the title of the invention should be given in Patent Cooperation Treaty also, and the title of invention should be given in USA and European uh, Patent Council Convention. Then second is in Japan you make claim, but the claim is description of invention, industrial application, prior art, then problem solved by invention. But then when you go to PCT, then it'll be on the technical ground. The background are the disclosure of invention, brief of descriptions, drawings, best carry mode for invention. Like these are different differences where the same patent law goes into a huge amount of difference. Now see, another important difference: patent granted on the basis of first to file. In the United States, it is not granted, but in Japan and Europe, one who files first for the patent will get a certificate of patent. But this is not the case in US, and this is not the case in India also. The one who invents first will get the patent, irrespective of the fact who files first. It is immaterial. One who invents first will get the right of patent. Now, filing. Now, filing. Now, when I talk about filing, filing can be done in any language under USA. That is English, Spanish, German, whichever language you want to, you can file it. And in Japan also, whichever language you want, you can file your application for patent. But then, in under European Convention, you can only file application in uh, English, French, German. That's it. Or any other official language does Europe has. So only those languages which Europe recognizes can only you can only file an application in that language. Then once patent application is published, no keep it secret is there. Then the patent till the patent is granted. Then uh, like under Japan and under Europe, before granting you patent 18 months before, you have to specify everything. Everything will be known to the patent office before the publication of patent. They'll not immediately publish your patent. They'll publish it only after you make them known. Then, the term of patent. The term of patent under US is for 20 years from the date of filing of application. But then in Japan, it is only for 15 years. The after the publication, that is after your invention is published, you can get only 15 years to use the patent. But then under European Convention, you will get 20 years. In India also, you get 20 years now for patent. Now, grace period is given. Once your patent application has been filed, anything additions you need to do with your invention, the grace period is given. See, only under US, you will get 1 year grace period. Under Japan and under Europe, you get only 6 months grace period. And under United States, there is there is no pre-grant opposition. But in Japan, yes, there is pre-grant opposition. That is before granting patent, they'll oppose. But then in Europe also, there is no pre-grant opposition. After granting only, they'll tell you. In India, there is pre-grant opposition. Before granting you a patent, they'll ask for oppositions. Then the formalities. The formalities under US and the formalities under Japan and Europe changes. These are less stringent in US and then reviewed by clerks and examiners. That is, your application is being reviewed by clerks and examiners under US, but under Japan, it is very strict. It is only reviewed by examiners, not by clerks. But in US, these are examined by clerks also. But in Japan, these are only examined by examiners. But then in Europe, it will be reviewed by clerks and examiners. The procedure in Japan is extremely strict as compared to patenting. In India also, the procedure is strict. Um, the percentage of foreign applicants under United Nations, there are 45% of people who are foreign applicants. But in Japan, only 10% of people are foreign applicants. But then in Europe, there are almost 50% of people who are foreign applicants. Hope I've cleared you the patenting system of different nations. Next, I go to industrial designs. Now, what is industrial design? Industrial design is nothing but like it is equal to patent. That there's no invention, but you make a art which is obviously new. That art is not known to everybody. Anybody knows it. Uh, that is, you put some design, application of some design to a car, to a pen, to a motorcycle, or anything, any designs you apply to anything, any ornament, any goods you can like you put your designs. Now there are designs such as there are three-dimensional designs, there are two-dimensional designs, then like there are patterns, there are lines, there are colors, 3D, 2D. That is pattern, some pattern or the other, lines, color, shade you give to a particular design. Such design should not match with others' design. Now, industrial designs are applied to wide variety of products such as industry, handicraft, technical, medical instruments, watches, jewelries, other luxury items, housewares, electrical appliances, vehicles, agricultural structures, textile designs, leisure goods such as toys and pet accessories. And like almost everything you go, even mobiles are designed, even toys are designed, then vacuum cleaners are designed, then your cars are designed, your bikes are designed, and your watches are designed. So there's no place where you can't see design. Everywhere it is designed. But design is basically something which is appealable to your eye. Now, what is appealable? Appealable is nothing but you should be very comfortable. After seeing this, you should be very happy. Oh, such a nice design. It has appealed to my eye. It should attract you by the looks. That's why design is important. Now, owner. Owner is a person who invented the design, who created the design. Now, one who creates the design has to register himself. That is, I create a Z design. Now, the Z design is my invention. Like, there's not equally Z, but looks like Z. And it is very cozy, it is very attractive. It is then such design has been approved by the authority and by accepted, and it is my design. So, nobody else can use my design without my permission. You cannot imitate a design. What is imitate? Imitate is nothing but you can't unauthorizedly copy somebody's design or take somebody's design into consideration. Now, why can't I do this? Now, because the investor who has invested a lot in that design will lose his money. So it is his economic right. I made a design. Now that design has been recognized by somebody. Then I should not taken away by my right should not be taken away by the other party. So that for that purpose, my design is to be protected. Now, protecting industrial design leads to the economic development. Now, this is a peculiar question which is to be understood. If I protect one person's design, many people will come and register. Like, they will not stop their creative ideas. For example, if I make a design and the design is loved by everybody, now then they'll use it, but then I'll get money because that design is registered. I'll sell it to the big companies. They'll do marketing of that design. Then design will be sold. That'll be approved by people around, and then like if I'm earning a money out of my design, then many people will be attracted with that. Okay, man, this man is earning money out of his invention, so we should also invent like we should also learn to invent such things. So it will in all what it will encourage others to make design, and it will lead to economic development of a nation. Now these designs are relatively in they are not costly enough, and they are easily to be protected. Like they are not time consuming. I can make a design. Like it's not inventing a product. It is only I have to invent a design. That's it. Now, apart from inventing a product, it's a big job inventing a product. But inventing a design is a small job, and the cost of inventing a design will take you not much. But then there's a general rule is that whenever you're registering a design, it should be new. I can't register a old design or known design. A design which is well known to me, and can I may get it registered? No. Unfortunately, I can't get a known design registered. Uh, Depends upon various countries. Few countries protect designs under copyright, but then India protects it under Design Act. There was a Design Act in 1911, 1911. That Design Act was repealed by India. Then again, there came a Design Act called Design Act 2000. Now, the protection given to an industrial design is very limited. You can't, like I say, copyright. Like the copyright has a long duration. The same duration can't be claimed under design. That is under Hague Convention, Hague Agreement, International Deposit of Designs. An applicant can file a single application for registration of design. And once he makes an application, he has to deposit at World Intellectual Property Organization's office so as to get his design protected. Then that is now it will be protected. That is once I submit my application at WIPO, my design will be protected against all the nations. That is the nations who are party to WIPO, World Intellectual Property Organization. They cannot use my design. That is where I get protection. I'll be protected by the law. That is, they'll protect me by themselves that my designs won't be used by any of the member nations of WIPO. Now, next I go to what are industrial designs. Industrial designs are nothing but a creative activity or a creative mind which will be applied to a mass produced item. Now, what will happen? It will attract a probable consumer. Probable consumer means consumer who is yet to buy. For example, let me give you an example. Who knows Kinder Joy? Kinder Joy is a kind of chocolate. It comes in brown shape. Uh, if you open it now, there's nothing inside Kinder Joy. There are only two little chocolate balls. That's it. And there's a toy inside it. There's nothing much in it. But then the design of Kinder Joy is so that the children are attracted to pick up that Kinder Joy, no matter where you hide it. Now, once you go to DMart, like DMart uh, is a shopping mall, like where you go for to purchase. Now, as soon as you reach the counter, no, they keep a lot of what is lot of chocolates, Kinder Joy. Now that the little kids get attracted towards the Kinder Joy and they pick it up, though it is not worth it. Like the price is more and the product is not worth. Then, then evolution of design protection. Now, see, though we are in new generation, we know new designs, new arts, and all, but then design is protected long back, like way back. The protection is there. Earlier, design was protected only on clothes. Uh, I'll tell you. There are saris now. When women who go to buy saris or to dresses, there are designs made on it, so they love it and they buy it. So earlier, designs were invented on material, cloths. Now UK, the UK was the first country which granted protection to designs, but that protection was only for 2 3 years. Sorry, 2 3 months. That is um, design, like who shall invent, like inventor, that is the person who invents the design. Now for to claim his invention, what he has to do is an inventor, he shall invent a design and print or cause to be invented, designed or printed and become a proprietor of any new and original pattern or, or patterns for printing linens, cottons, chalice, or Muslims. The contribution of such design is growing textile industries was thereby recognized. See, earlier the designs were applied only to textiles. Like you can put a design on cotton, you can put in a design on a linen cloth or terracotta cloth. Now, all these clothes are what are being worn by people. Now you see, if you buy silk saris and all, no, they put designs of animals. Basically, the designs concept started from the cloths. Primarily, the designs were given to the cloths and they were protected only for 2 3 months. But until the Act of Designs Act 1942 came into force, they only gave a very little protection to designs. But the Designs Act made the process little vast. It applied to embroidery. Embroidery is like you give it to additional stitching. The thing is already stitched, but you do some designs on your clothing. New and original designs, whether such designs have been applicable to ornamenting article of natural or such design to be applicable to pattern offer some shape configuration. Now they took a little long, like they took a little broader concept. They took designs, they took shapes, they took manufacturer, they took whether the design is natural, whether the design is applicable, whatever it is, like whether it is recognized, unrecognized, whether it's been done, whether it's been not done. They have like now that designs are being broadly categorized after the codification of law. Uh, that is embroidery, weaving, sieving, modeling, casting, embossing, engraving, whatever you do. If you even if you emboss, engrave, or stitch or embroidery, whatever you do, you are creating a new design which was not there before. But then today, this concept has become a little absolute because nobody prefers for a design in the cloth. Then again, design law took a importance in France, where like French Revolution in the year 1793. There was like in 1806 there was a special law which talked about industrial designs. I'm talking about France. Then next is legal protection of designs. Now, legal protection means what? Once you get the license, once you get the authority over a design, nobody else can claim such a right over your design. This is your legal protection. Next is subject matter of protection. Now, why design is protected? Design is nothing but an idea or a conception. Now, I make a design. I make a design by what? With my idea, with my knowledge, with my conception, uh, with my originating or my creativity which I have. By that, I create a design, and that design is absolutely mine. And the design which I've created will give me exclusive right to use it. Now, basically, the designs has to be applied. There is, if I make a design, that should be applied. That should be applied on a product so that the product looks good. The product looks attractive. Only then I can claim protection. Then once your design is protected, it will protect you from other manufacturers. No manufacturers in any case can take away your invention, take away your design, which is new. That is idea which I have, a design, may be something which can be expressed, an idea in the form of design, which is expressed by me. Now, which can be expressed by me in two-dimensional way or three-dimensional way. Now, it is me who is expressing it. That is, such kind of definition is defined under Designs Act 1949 UK. UK says it is nothing but your idea which you have expressed in two-dimensional or three-dimensional way. Such kind of definition is given in UK. Then UK refers features of shape, features of a shape, configuration, pattern, or ornament. For example, I design a door. I design a door with so many uh, like so many artistic works are there. I tell the entire story in that one door. For example, there's the oldest theft or murder story. Now I tell that entire story in that one door itself. I design it. Now that design is what very peculiar. Nobody else can do it. This is by your art you have done it. Many people might draw, but I have drawn it in such a way that a single door tells you the entire story. That's why my art is something very different from others, and that's why I can claim protection under Designs Act. Then, when I go to UK, there's an act called Copyright Designs and Patent Act 1988. Now, UK defines designs. Designs as an aspect of shape or configuration, whether internal or external, of the whole or part of an article. Whether you apply something to a product, whether you applied completely or you applied half of it, or whether you applied inside, whether you applied outside, wherever you do it, it will be still considered as design. Then, then whatever designs you are claiming, it should be novel, that should be new, and it should be original. That is like we saw under patent that it should be new and inventive step. But when you come under designs, no, the design should be new and original. New is what? It has been never seen by anybody, and it should be original means what? It should be made by you only, and nobody else has made it. Then, TRIPS agreement. The members of WTO may incorporate the provisions that industrial design protect shall not extend to designs dictated eventually technical or functional. Now, see, you cannot you cannot ask for protections for those designs which are dictated. Dictated means what? Let me tell you a screw. Now, screw is what? It is a dictated design. Now I have to tight it. It will go circle, circle, circle. I can tight it. I can lose it. If I if I revolve it clockwise, it will get tight. If I revolve it anti-clockwise, it will get loose. Now this is understandable. This is a dictated design. Now such kind of design is not original, and you can't claim registration for such designs. Now, many articles are there. That is belt. Now, belt is there. For example, let me take belt. As sometimes the hook is narrow. Sometimes the hook is small. Sometimes there's a bullet kind of a thing. Now, there are various designs in the belt. But this is obvious thing that you may design the belt in any way or the other. The ultimate purpose is the belt, and it is what it is being designed by a machine, a dictated machine. That's it. Now you can't claim protection for that. Next is rights of industrial design. Now, the right for legal protection. What is legal protection? Once I make a design, I'll be the owner of the design, and nobody else should use my design. It's a kind of legal protection given to the creator of a design. Nobody else can claim such a right because it is exclusively to him he can claim such a protection. Now, will it be given to a employee? Now, suppose I'm an employee in a company and I've designed it, but I get paid for it. But will I be given such kind of protection? No, because I am under an agreement with that with my owner who is working for me, like whom I am working for. Now, in such a case, I cannot ask for protection in such a way because my though it is my design, but I work under a contract, and my owner can claim such a design because I am his employee. And ultimately, the legal protection will be granted to the employer and not the employee. For example, I am the employee somewhere, and I am a manager of a company, and I say, "Sir, our car is not rated high because it looks very big. Like it looks very big, it is ugly. Kindly change the design so that it looks very attractive. Let the doors open at the top. Let there be windshield." Now, these are the ideas given by me. But then the question remains that can I get the protection because I gave the idea? No, I can't. No, I can't get the protection because I am not the owner of the product. I'm only the employee, laborer. So the employer who employed me will get the protection and not me. Then the duration of design. Basically, the duration of design is 10 years. In India, designs are protected for 10 long years. Like no, like other countries also, the basic is 10 years only. Like they protect the designs for the period of 10 years. Then every 10 years, you're supposed to renew it. That is, once I register my design, I can keep it for 10 years. Then again, if I want the protection again, then again I have to renew the application. Then next is acquisition of rights. Now, when will you acquire the rights of design? Only when you register. Before, like even if you invent a design and if you don't register, you will not get any kind of right. You will only get the right only when you have invented. Only the inventors will get a right, and the non-inventor will not get a right. As well as the register, the person who registers will get a right. Like there'll be exam same like the same procedure for patent. There'll be examination. Then after that examination, there'll be they'll see whether the design is new, whether the design is applicable, or whether the design is an idea of somebody. They'll check all this, and if you fulfill all the requirements, only then they'll be getting a registration. Then they'll check whether there are past designs like this. If I submit a design, no, they'll check in their search engine. Like this is the design submitted by Mr. Abdul, but whether there are any such designs which correlate to this design, any design which correlates to my design, then I'll not get a registration. I'll not get protection. Next is nature of rights. Now, the basic nature natural right of a design is right of exploitation. Now, being an inventor of a design, only I have the right to exploit my invention, and nobody else has a right to exploit the invention. There is nobody else can use my invention without my permission. Then, like what they can do is they can like if I invent a design, I can put it on any article, or I can give it to somebody to put it on the article because I am the owner. Uh, then I can import articles on which designs can be applied. Only I can import because I made this design. So I can import any article for the purpose of applying my design which I've invented. Then I can sell my design. I can hire my design. I can offer the design for sale. But it is only I can do. Nobody else can do it. Then the duration of the rights are there with me until I renew it. Basically, the right remains with you for 10 years. Then if you again renew it, again it will go for 10 years. But then the protection of design is for very a short period as compared to copyright. Copyright is for 60 years, but then only design is for only 10 years. Then relation with copyright. Now that is the same like same designs are somewhere in some countries they take protections from copyright law. That is since copyright is also an intellectual property and design is also an intellectual property. In some countries they grant designs a copyright. That is the term of design may increase depending upon for what it is given, whether it is uh, like whether it is taken under design law or whether it is designed under copyright law. Yeah, in some countries, design is concurrently protected. Design is protected under trade, under copyright also, and under Designs Act also. Then, if the inventor chooses only one law, the inventor says, no, no, I'll register my design under Designs Act and I'll not register my design under Copyright Act. If you choose either of the one, then you cannot go further. That is, your design will be registered under Designs Act, and you can't claim any protection under copyright law. This double protection is not there in India, but this double protection is in France and Germany, where you can protect your protection under industrial design law also and on copyright law also. But in India, there's a specific law called Designs Act 2000, and there's a specific act called Copyright Act 1958. So there are two different laws in India. You cannot claim one single protection. You're getting it? But only in France and Germany you can claim this. Okay. Any doubts? Anybody? Anybody has any doubts so that I can clarify your doubts?
So it's today's class is done, sir, with this. All,
Yeah.
yeah.
Today's class is done, man.
Okay.
Excuse me, sir. Madam, can you get the PPTs of this one, madam? Sometimes